File item 25, that's AB 1050. Clerk will read.
Assembly Bill 1050 by Assemblymember Lowe, an act relating to state employees.
Mr. Lowe, you may open.
Thank you very much, Mr. Speaker and members. Assembly Bill 1050 would require nonprofit organizations participating in the state's Giving at Work campaign to submit its non-discrimination policy to the Victim Compensation and Government Claims Board. This bill has no opposition and enjoys bipartisan support. I respectfully ask for your aye vote.
Thank you, Mr. Lowe. Seeing no discussion or debate on this item, the clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll. Tally the vote. Ayes 56, noes 3. Measure passes. File items 27 through 29 pass and retain. Moving to file item 30, that's AB 1390. Clerk will read.
Assembly Bill 1390 by Assemblymember Alejo and others, an act relating to groundwater.
Mr. Alejo, you may open.
Thank you, Mr. Speaker and members. Today I present AB 1390, a bipartisan bill that will bring new efficiency to the process of adjudicating water rights and groundwater basins. When the governor signed the Sustainable Groundwater Management Act, or SGMA, last year, there was an interest in streamlining the adjudication process. AB 1390 will work in conjunction with SGMA to do just that. For this reason, the bill has attracted 20 co-authors from both parties and both houses of this legislature. The goal of this bill is to clarify court procedures that apply to comprehensive groundwater adjudications to reduce the time and improve efficiency of the process, thus reducing cost. Specific provisions of the bill will encourage early settlement and avoid undue disruption of local groundwater planning. In much of California, management of groundwater resources will be made easier by the identification and quantification of local groundwater rights, the purpose of an adjudication. But currently, that process is longer and less efficient than it should be. Making groundwater adjudication more efficient will relieve the burden on the courts, and at the same time, it clarifies groundwater rights, bringing a double benefit to the entire process. While this bill will make the process quicker and easier, we are under no illusion that adjudications can be made short and easy. However, this bill will certainly make the process more efficient while protecting due process rights for all involved. This bill received unanimous bipartisan support in the Assembly Natural Resources, the Assembly Judiciary Committee, and the Appropriations Committee. I respectfully ask for an aye vote.
Thank you, Mr. Alejo. Seeing no discussion or debate on this item, clerk will open the roll. All members vote or desire to vote. All members vote or desire to vote. All members vote or desire to vote. Clerk will close the roll, tally the vote. Ayes 66, no 0. Measure passes. Members, we're moving back in the file to file item 26. That's AB 1100. The clerk will read.
Assembly Bill 1100 by Assemblymember Lowe and others, an act relating to ballot initiatives.
Mr. Lowe, you may open.
Thank you, Mr. Speaker and members. Assembly Bill 1100 will adjust the filing fee that is paid to the Attorney General when a proponent submits a ballot measure, proposal, or referendum from $200 to $8,000. The $200 fee was first set 72 years ago to cover administrative costs by the Attorney General to analyze a proposal and prepare its title and summary. Information obtained from the Attorney General's office revealed that the average cost for initiative proposals submitted for the past 4 years, the average was about $8,251 per initiative. This reform is overdue, but more importantly, will defer frivolous proposals from being submitted. This is a good government reform bill, and I respectfully ask for your aye vote.
Thank you, Mr. Lowe. Mr. Lackey, you are recognized.
Yes, thank you. I respectfully rise in opposition to this bill. We hear a lot about the initiative process and how it has become a tool of the wealthy. This bill would make it more so by effectively excluding voluntary citizen groups from the initiative process. It would make the wealthy special interest groups the only ones who could afford to play in the ballot initiative process. Proponents of this bill say it is necessary to cover the administrative costs of preparing the ballot initiative. However, these numbers don't add up. If the $200 filing fee were increased to reflect the inflation since 1943, it would be about $2,700. It would not be $8,000 as proposed. Increasing the filing fee by 4,000% is simply a money grab which will make it harder for Californians to make their voices heard, and I urge a no vote.
Thank you, Mr. Lackey. Mr. Ridley Thomas, you are recognized from your desk.
I rise in support of AB 1100 by the gentleman from Santa Clara County. This measure is an intelligent update to our elections infrastructure. The system is quite outdated, and I thank the gentleman from an innovation center for helping us innovate with this bill and promote equity in the system and resources that are adequate to make sure that we can run election systems from a state level that makes sense. The election system is severely underfunded, and this is more than a reasonable attempt to make sure that we have the resources available for an efficient system. Thank you, Mr. Speaker.
Ms. Grove, you are recognized.
Thank you, Mr. Speaker. As the Vice Chair of Elections, I rise in opposition of this bill. I truly, truly understand the author's position behind the bill. I mean, I think it targets a particular individual that I'm sure we've all read about, who is, in my opinion, vile and reprehensible for submitting such horrible language on a ballot measure. But the issue is not about that person. The issue should be about the people's right to be able to have a grievance against their government through the initiative process if that's what they choose to do. It's to access the initiative process to overturn legislation that they don't agree that this body has passed. And to limit their ability to exercise that speech is again, not even something that we should even consider doing. And I think the people that vote will take notice of that. You're actually increasing their costs to exercise their freedom of speech. And like my colleague from Lancaster said, that this body often accuses the wealthy of manipulating the election or the initiative process. Well, this increase in cost or fees that go up to $8,000 is going to find a small or an individual that doesn't have the means to support an $8,000 initiative, but truly does believe in a cause that they are advocating for, would not be able to pay that filing fee, or a nonprofit organization. And like I said, I understand where the initiative attacks on initiatives are going to come from this body because of an individual that did some things, or that filed an initiative that should have never been filed. But we still have to stand and allow the people of this state to have the freedom to be able to have a grievance or file an initiative process without the overburden expense to have to do that. And even if you were to take into cost of living over the period of time since the initiative process has been updated, like my colleague said, it's $2,700. It is not $8,000. I would ask for a no vote.
Seeing no further discussion or debate on this item, Mr. Lowe, you may close.
Thank you very much, Mr. Speaker. Members, I just want to clarify and reiterate again that this has not been updated in 72 years, and also mention the fact that individuals, when qualified, can recover these costs as well. So I respectfully ask for your aye vote.
With that, the clerk will open the roll. All members vote who desire to vote. 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 Clerk will close the roll. Tally the vote. Ayes 46, noes 24. Measure passes. Members moving up in the file items 31 and 32 are pass and retain. Moving to file item 33. That's AB 359. The clerk will read.
Assembly Bill 359 by Assemblymember Gonzalez and others, an act relating to grocery workers.
Ms. Gonzalez, you may open.
Mr. Speaker, AB 359 seeks to protect up to 383,900 grocery workers in California from losing their jobs during large grocery mergers. It would require grocery stores that are larger than 15,000 square feet to retain eligible workers during a 90-day transition period when changing ownership. Eligible workers will be considered for continued employment after the 90-day transition employment period by the successor employer, but there would be no obligation to hire the retained worker. The cities of San Francisco, Los Angeles, Gardena, Alameda, and Santa Monica have adopted this grocery worker retention ordinance. In 2011, the California Supreme Court ruled in favor of the ordinance that was passed by the Los Angeles City Council in 2005, and this bill mirrors that ordinance. I'd like to address the opposition's arguments, quite frankly. Permission to use a prop?
Without objection.
So it's come to my attention that the opposition did circulate their own facts about my bill, and I just want to address them because they're faulty, quite frankly. First, in their facts, they suggest that the California WARN Act protects the workers in this type of situation. The WARN Act actually applies to closures and not transfers of a grocery store. And so this only applies to when a grocery store changes ownership. As a result, the California WARN Act does not apply here. The next thing that they imply is that AB 359 would subject employers to significant risk of litigation. I would want to remind this floor that a member of our legislature asked me to take the private right of action out of the bill. I did that on this floor. It was an affirmative right of action. What they're talking about is PAGA, a Private Attorney General's Act. Now, I'd be the first to admit that there are some things wrong with PAGA, but let's be clear what that is. It is an act that deals with the entire labor code. This affects every labor vote that we take here. In fact, I was sworn into office 2 years ago today. I have voted 69 times on bills, as has a majority of this assembly, that would allow PAGA to interact with that bill. Not once have I heard somebody bring it up as an issue. Suddenly, this has become a red-hot issue. But let's talk about what PAGA does in this circumstance, not the two bills that we voted on last week off the floor where PAGA related. But in this circumstance, it's a Category 3 PAGA litigation. That means that an employer has 33 days to cure if there's a violation. So if somebody wants to sue on retention, first, they have to get the permission of the state, and second, they have to notify the employer, which has 33 days to cure. That's a good litigation strategy. It means that court cases don't happen. Third and finally, they talk about this being some underhanded way to organize a union. What amazes me about that argument is the very letter that they sent to me has the opposing argument made. They suggest, in fact, rightfully, that successor agencies don't have the right to bargain if they're forced into being successor agencies. Only when they voluntarily retain workers are they subject to collective bargaining. They know this because they wrote an original letter to me, although they now circulated information to the contrary. I'm fine having a discussion about whether or not we think middle-class jobs should be saved. Whether people who have given 20 or 30 years to a big corporation that's being taken over in a Wall Street-style merger should have 90 days to be able to prove themselves or find a new job. I'm not okay with arguing things that aren't true, and unfortunately that's what the opposition has put out. I respectfully ask for an aye vote.
Seeing no discussion or debate, members, if you wish to be recognized, please do so during debate. Mr. Gallagher, you are recognized.
This question of the author.
Without objection.
As you know, when we discussed this in Judiciary Committee, one of my concerns was that this would impact a lot of small and family-owned grocery stores in the state. As I think it was pointed out, 41% have private equity ownership, but we're talking about close to 60% that don't. So that same group of family-owned businesses are going to have this impediment when they try to acquire a new store and go forward. And at least part of when you take over a new grocery store is that that store was not doing well. You're trying to keep it alive in the community moving forward. So you need to make personnel decisions, and this could inhibit that. So could you maybe speak to the impact that this would have on the small mom and pops, if you will, or maybe mom and pops is not the right one, but family-owned grocery stores?
Ms. Gonzalez.
This only affects grocery stores that are over 15,000 square feet. I would love to say that that's a mom and pop. It's not. That is a large grocery store. And although 41% of these grocery stores are now acquired, private investments have taken over, it is a new day. And so when we talk about family-owned grocery store, yes, our largest grocery stores were once family-owned. But then they're acquired, they're leveraged, they're bought and sold on Wall Street. And quite frankly, I don't think that there are many mom and pops who are operating 15,000 square feet grocery stores and then want to acquire another one. But even if they did, they would simply be required to maintain a workforce for 90 days, after which time they would be more than, as long as they gave them a good shot, allowed them to apply for a job. They could say no to every single one of those employees. It's a cushion. It's not a mandate.
Thank you, Ms. Gonzalez.
Just a second question of the author.
Without objection, with the reminder, we do not engage in colloquy on the floor. Without objection, you may ask the second question, Mr. Gallagher.
And just my second question was regard, the other issue I brought up was with regard to it appears an exemption for superstores who are not primarily engaged in grocery, but still are competitors in the market, and this could cause, an unlevel playing field between what I'm concerned about, the family-owned grocery stores and superstores.
Without objection, Ms. Gonzalez, you may address that now or in your close.
I'll address that. Any other questions in my close?
Thank you, Ms. Gonzalez. Ms. Grove, you are recognized.
Thank you, Mr. Speaker. I rise in opposition of this bill. The bill actually says what the author says, that it takes 90 days and you can't terminate the employee. You have to allow the successor agency that's purchasing the grocery store to keep those employees. And just like my colleague said earlier, that, you have to make personnel decisions and decisions on making a grocery store succeed or survive, or any business. It's my understanding that after the 90 days, even though there's a cure period under PAGA, and PAGA is a hot issue because we have a lot of trial lawyers in the state of California who are abusing PAGA under modern day extortion with the protection under the law. But so that's why that's a hot issue. But in this particular situation, if you have an employee who has who stays on 90 days and then the successor grocery store chooses not to hire them, they'll have 33 days to cure it, meaning 33 days to change your mind or I will sue you. And the penalties under PAGA are $100 per paycheck for the first pay period violation, $200 for the second paycheck, and every violation after, going back 4 years. So if you have a couple of hundred employees or 100 employees, those fines and penalties can be millions of dollars that are not negotiated or being able to be reduced by a judge. So that's why tying this issue to PAGA is a huge problem, not to mention that even with the cure notice, like I said, you have 33 days to cure, so which means that even though you may have a bad employee that you don't want to retain and you don't want to bring in board, if you say, no, I don't want to hire you, and they go, look, you have 33 days to cure that, meaning you have 33 days to change your mind, or I'm filing a lawsuit against you, the penalties under PAGA are so severe, the employer would have no choice but to accept that employee's request to be hired, to accept it, or face severe penalties based on every single paycheck that they've written over the past 4 years. So it's just a law that creates an unfair burden on all of the employers, especially if they're trying to salvage companies that are in a transition. I respectfully ask for a no vote.
Mr. Wagner, you are recognized.
Thank you, Mr. Speaker. The author tells us not to worry, that after the 90-day period you can just go ahead and fire all of your employees if they haven't proven themselves. And I think what we've heard from my colleagues from Northern and Central California in the questioning has exposed the fact that that's simply not true. Bottom line is this: if you've got a workforce and you give them all 90 days and then at the end of the 90-day period you fire them all, there is not a lawyer in this state that would not salivate at the opportunity, because by definition what you have not done is given each one of them an individualized opportunity to demonstrate their ability to keep that job. It does not matter if, for example, you've got a store, your neighborhood is changing. For example, perhaps more of our Hispanic constituents are moving into the neighborhood, and you would like to reflect that change and hire those workers in your new establishment that perhaps is catering to those to that new demographic. Or perhaps some more of our Asian American constituents are moving into the neighborhood, and you'd like to change the character of the grocery establishment to reflect that new neighborhood characterization. You cannot, under this bill, respond to that demographic change and make the necessary changes in your workforce. Because, as I say, there will be lawyers lined up out your door waiting to be hired by every one of those workers. Because the actual language in the bill, despite what the author tells us about how you can go ahead after 90 days, the language isn't there, the law isn't there. And unfortunately, the bill does not respond or allow our business owners in our communities to respond on the ground in real time to the very real changes in the demographics of their neighborhood. And that's going to hurt workers. It's not going to help them. We aren't talking about a zero-sum game here. We aren't talking about firing a whole bunch of workers and hiring nobody else. We're talking about hiring different workers coming up out of that community, maybe that are now more reflective of that community than they were in the past. And we up here, because we're so much smarter than they are and know better than any one of our individual business owners, are saying, no, you can't do that. Well, we're not smarter, and we shouldn't be saying that. We should say no instead to this bill and allow our business owners on the ground to respond to our constituents on the ground rather than pretend that we up here know better. I urge a no vote.
Mr. Hernandez, you are recognized.
Thank you, Mr. Speaker. Members, as chair of the Assembly Committee on Labor and Employment, I rise in strong support of this bill. With the changing dynamics in the grocery industry, this measure is needed to protect workers, maintain a good standard of living, and protect consumers. I'm really struck by the figure that 3,200 of the biggest grocery stores in California, 41%, are now owned by private equity firms. We know that such firms don't always have the best interests of workers in our local communities at heart. So I think this bill is an important check to protect our middle-class jobs. Folks, we all say that we're all in support of protecting our middle-class jobs and stopping the erosion of good-paying jobs in California. Well, we have an opportunity to do that just here. And we have every ability here to stand up for these workers that depend on these jobs to sustain for their families. So let's send a message to our community that we back up our worker. We back up those workers that enjoy benefit, access to health care, proper hours, and the opportunity to sustain their families. Your I vote here today is supporting the family in your community. Thank you.
Thank you, Mr. Hernandez. Mr. Eduardo Garcia, you are recognized.
Mr. Speaker, members, I rise as a co-author to the bill and chair of the Jobs Committee. I represent a county that has 21% unemployment. Sometimes we have to push public policy to ensure the retainment of jobs in California. I think this bill does exactly that, protecting the opportunity for workers to stay employed until the company has its ability to make a proper assessment in order to make a permanent hire. I cannot afford, members, for Imperial County to continue to see rising unemployment rates for this state. So I respectfully ask for your aye vote as a co-author to this bill.
Thank you, Ms. Garcia. All debate having ceased, Ms. Gonzalez, you may close on the measure.
I just want to reiterate, twice last week we voted for bills that are subject to PAGA, 69 times in the last 2 years. Once last week, this entire body voted for a bill that had worker retention for airport workers. On the books of our state, we have worker retention for janitors. In nearly every one of our airports, we have at some point adopted worker retention ordinances. This isn't new. There aren't lines of attorneys lining up to sue these agencies or these grocery stores in the 5 cities that have already passed this. This allows people 15 days, not 4 years of back pay, 90 days. I'm cutting off their days real quick there. But it allows 90 days with a 33-day period to cure for the employer. I respectfully ask that you look at the facts. You read the bill. I took out the portion that's a private right of action that allows it to extend. This is, in fact, less litigation happy than a lot of the bills that we pass through here. But when Wall Street style mergers, private equity firms, and leveraged buyouts hit the grocery industry, a high number of jobs are put at risk. Wages are reduced and workers are fired. It's unsustainable for many of our communities. Historically, these are some of the last good-paying middle-class jobs that have played an important role in our communities. They're jobs that can't leave California. They can't be outsourced to another country. They're part of the backbone of our very communities. I think we should respect our grocery workers, and I respectfully ask for an aye vote.
Thank you, Ms. Gonzalez. With that, the clerk will open the roll. All members vote or desire to vote. All members vote or desire to vote. All members vote or desire to vote. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. All members vote or desire to vote. All members vote who desire to vote? All members vote who desire to vote. The clerk will close the roll, tally the vote. Ayes 42, noes 26. Measure passes. Members, I am prepared to lift the call on file item 24. That's AB 1017. The clerk will post. All members vote who desire to vote. Clerk will close the roll, tally the vote. Ayes 41. All members vote who desire to vote. All members vote. Members, we're going to move the call. File item 24 is back on call.